Our constitution guarantees us our fundamental rights, and the fundamental rights are rights which are protected against state action. But there is one right which is protected against not only state but against any other person who violates this right. This is right against exploitation under Articles 23 and 24 of the Constitution. What is exploitation? Exploitation is to take advantage of somebody else's weakness and make him do certain things which may be beneficial to a person. So, exploitation can be done in several forms. Here in Article 23 subclause 1, 3 forms of exploitation are considered. That is, first of all, when we say exploitation, one is trafficking in human beings, which means selling and buying human beings like chattels, like goods, or like property. So, human beings have to be considered as human beings with fundamental rights, with inherent rights, and no one is allowed to buy and sell human beings as slaves or trafficking in women for illegal purpose, for immoral purposes, or trafficking in children for illegal purposes. All this is prohibited. That is one word, traffic in human beings. Second is begar. Begar means making a person work without paying him anything. That is begar. So, without giving him work with remuneration. He is made to work, but he is not paid. He may be paid in some other forms. He may be made to work by promising him that he will be looked after or his family will be looked after. But if he is made to work without any remuneration, that is begar. This form of work was in prevalence even before the coming into force of our constitution. So, to prohibit that, this word has been added. Then forced labor. Forced labor or bonded labor was prevalent in India by the zamindari system before the constitution came into force, that is during the British rule itself. So, after we got independence and our constitution came into effect, we decided to do away with these forms, that is bonded labor, and there was a law enacted for that purpose. These 3 things are main forms of exploitation of human beings, and anyone who engages in trafficking in human beings or begar or forced labor, he is declared to be an offender, and these things are prohibited and declared as an offence under the Constitution under Article 23 subclause 1. What is the meaning of an offence? So, an offence means it is something which is prohibited under the law and there is a punishment for that. So, if it is a punishment, there has to be a law for that purpose. So, laws are enacted for this purpose, and according to that, there is a punishment for these acts of any person. There is an exception for this purpose. Article 23 subclause 2 speaks about one exception. State can impose compulsory service for public purposes. For example, if the state needs the service of some persons or service of citizens in times of calamities, in times of emergencies, in times of war, then state can impose service. It may call upon the citizens to join hands for public purposes. That will not be considered as a begar or bonded labor or a different form of an offence, because this is an exception. When the country needs us, we have to be there for the country. So, that is one exception to this article, but there is another exception. When the state imposes compulsory service, state shall not discriminate on any grounds. State will treat all the people or all the citizens on one ground, that they are equal and they are citizens of India. 5 grounds are stated, that is, they shall not be discriminated on the ground of religion or on the ground of race, on the ground of caste, on the ground of class, or any of them. So, this is a mandatory provision that no one shall engage in exploitation of these forms, that is, all these 3 things are described, and if they are violated, there is a punishment. But state can impose compulsory service provided that it shall not discriminate among any individual, among any person on these grounds. Now, there is one important case relating to bonded labor, that is Bandhu Mukti Morcha versus Union of India in 1984. Here, Laborers were working in stone quarries in Haryana, and the owners of the quarries made them work in such conditions which were inhuman conditions, pathetic conditions, where they did not have any medical aid, nor any safety rules were followed, nor any relevant laws were enforced. They were bonded laborers, and they had to work day and night without any safety or without any basic facilities available. There were no places where they could get water, or their families could be there, or their children. They were staying there in such human conditions. The whole family was staying there without any education. The children were loitering here and there. It was a very sad and pathetic condition. This came to the notice of one organization, that is Bandhu Mukti Morcha. It is a public organization which, looking into these facts, approached the Supreme Court on the ground of a public interest litigation, filing a public interest litigation for the remedy for this. Now, in this case, the Supreme Court has given a very lengthy judgment interpreting the Constitution and the fundamental rights of an individual under the Constitution of India. That is, it referred to Article 21 and 23 of the Constitution. Besides Article 23, that is right against exploitation, their right of life and personal liberty under Article 21 was also violated. The court said that everyone has a right to life, and right to life means right to live with human dignity. That was a landmark judgment by the Supreme Court, and the court gave a direction to the state to free the bonded laborers and to give required facilities for rehabilitation of those laborers even after they leave that particular place and they start their work somewhere else. Then the next article which we are studying is Article 24. Article 24 is relating to children. That is, again, exploitation of children should not be made. So there is a prohibition of employment of children in factories, etc. That is the marginal note or the heading of the article. It says that children below 14 years of age shall not be made to work in factories, mines, or other hazardous employment. This is the crux of Article 24. So, a child should not be exploited. It should be able to enjoy its childhood to the fullest. But very sadly, in India, there are some people below the poverty line who send their children to work in factories or mines or any places where they take them for work without giving them even sufficient payment because he is a child. So, here the direction was given by the court in several cases that children below 14 years of age should be protected, and they are not allowed to work in any such places where there is hazardous employment. What is the hazardous employment? Hazardous employment means a employment where the chemicals or due to that environment there, sharp objects or maybe fire or maybe heavy machinery, the children are exposed to all those things, and therefore they suffer injuries and they also lose their lives sometimes. For example, when we say that children are working in cracker factories without any gloves, without any things to protect their eyes. So in such cases, this article comes to help, because if any person approaches the Supreme Court on this ground, the court will take cognizance of this matter and immediately he will be freed. For this purpose, we also have laws to enforce these provisions. Now, which are these laws enacted to prohibit exploitation of human beings or particularly of children also? Let us look into the laws. For prohibiting trafficking, there is a law which has been enacted in 1956, that is the Immoral Traffic Prevention Act, which was again improved, and it was replaced by the Immoral Traffic Prevention Act of 1986. Then bonded labor, we have the Bonded Labor System Abolition Act of 1976. We also have one law, that is Child Labor Prohibition and Regulation Act of 1986, which prohibits child labor. There are several other laws also which go along with these laws. But the question is there to see whether actually the constitutional provisions are really enforced through these laws, or whether some more improvements could be done to see that they are implemented. Because when we see that child labor, especially when children are sent to work, their parents send them to work And if the state wants to enforce, sometimes the parents themselves say that we have a right to send our child to work. So there are requirements, or it is necessary to see that the children are protected, and also the persons who are working without any facilities are also prohibited. So these laws are there to prohibit exploitation, but we should remember that in our constitution we have this fundamental right, that is right against exploitation, which protects a human being, and it is necessary that we are aware of these laws so that steps can be taken when any violation of this particular right to life is done, not only by the state but by any other person. So this is right against exploitation under Article 23 and 24. I hope you have learned something from this video. If you have liked it, please share it with anyone who you think would be interested. Please leave your comments and I would be happy to reply to them. Do subscribe to get more information on everyday law and legal studies. Thank you.